Hello, this is Dr. Dennis Saccuzzo. I'm here with Dr. Nancy Johnson and Professor Andrew Poplin. We're debriefing the February 2015 California bar exam. On to question six. Question six was a wills trusts crossover, and we'll come back to the actual law that we're going to need. But let's go to the hypothetical first. Dr. Johnson, can you please read the hypothetical?
I, of course, start with the calls to figure out what the subject is. Call one says, is Zoo's petition likely to be granted? It refers to a document, an action someone has taken that has to be in the fact pattern. Look at the paragraph above that says Zoo has petitioned the court to modify the trust to provide for the care of its animals generally. So that tells me we're operating in the area of trust.
All right, just seeing that call to question or write down on the side, how do you modify a trust? There are two legal theories, the Cypre doctrine and the doctrine of changed circumstances. One or both of those theories must be discussed here. That's my first observation.
Call two, what rights, if any, do Greg, Susie, and Zoo have in Tess's estate? This has the instruction answer according to California law, and that instruction is embedded within call two. California tests majority law in trusts, with the exception of some of the trust doctrines where they want you to know the California probate code. So I'm not sure right now whether call two is about wills or whether call two is about those particular trust provisions, omitted spouse, omitted child, lapse, anti-lapse, and the distribution rules.
Right, but this is a common structure that everyone out there should be familiar with. The first call makes no mention of the law to discuss, which means we're using majority rule, which is what we do in trust. The second, answer according to California law. Therefore, we're going to be in the probate code.
At a glance, I see that the hypothetical has 5 paragraphs that give me events from 5 consecutive years. Start with in 2011, Tess, age 85, executed a valid will, leaving all her property in trust for her grandchildren, Greg and Susie. Income from the trust was to be distributed to the grandchild or grandchildren then living each year. At the death of the last grandchild, any remaining assets were to go to Zoo for the care of its elephants. In 2012, the court appointed Greg as conservator for Tess because of Tess's failing mental abilities. In 2013, the court authorized Greg to make a new will for Tess. Greg made a new will for Tess, leaving Tess's entire estate to Susie and himself outright. Greg, without consulting Tess, then signed the will in the presence of 2 disinterested witnesses who also signed the will. In 2014, Tess found a copy of the will drafted by Greg and became furious. She immediately called her lawyer, described her assets in detail, and instructed him to draft a new will leaving her estate in trust to Susie alone and excluding Greg. Income from the trust was to be distributed to Susie each year. At Susie's death, any remaining assets were to go to Zoo for the care of its elephants. The new will was properly executed and witnessed. In 2015, Tess died. That same year, Zoo's only remaining elephant died. And now, as we read earlier, Zoo has petitioned the court to modify the trust to provide for the care of its animals generally.
All right, so the first thing we have to do is figure out what the controlling will is. In all wills hypotheticals, you don't just get a will and everything is great. At the end of the day, it gets distributed according to its terms. Instead, we have wills formed, some valid, some not. If we look at paragraph 1, the 2011 will is stipulated as being valid. That is a valid will. It leaves property in trust. The trust is operating right away during Tess's lifetime. It's going to give Greg and Susie a life income estate. In other words, they're going to get the income from the trust for life. And then what is left at the end of the death of the last survivor is going to go to Zoo. So that's valid will 1. We have to see what happens next. What happens next is Greg gets appointed as a conservator. Greg is the grandson. and it's because of Tess's failing mental abilities. Well, in 2013, Craig creates his own will again. He just recreates the will. There's key facts in here that we see. The key fact is it said Greg, without consulting Tess, then signed the will. Also, what happened here in 2013? He changed the will, and instead of following the intent of Tess to care for the animals, to provide the income life estate, he basically rewrote the will to give himself and Susie an outright gift. Now, whether you know the law of conservators or not, it's basically we can see here that this would be a breach of trust. And that's what's going on here. Greg has breached the trust of Tess because he is not following her wishes, but he did not consult her. Instead, he appears to be operating on his own. Now, the fact they used the will's formalities, it's signed in the presence of two disinterested witnesses who also signed the will. Just the fact that they followed the will's formalities is not going to be good enough here. In my opinion, this will is invalid, at least at this particular point in time, because of breach of trust. However, we have a third will now, the 2014 will. And what we see here is Tess becomes furious. Now that tells us that Tess is not completely disabled. She has the ability to look at the will, to read the will, and figure something's not right. She immediately calls her lawyer. She describes her assets in detail and instructs him to make a new will. And then it says the new will was properly executed and witnessed. The big issue here is this 2014 will valid? And then if so, what does it do? Now, to determine whether or not this will is valid, the key here is, does Tess have testamentary capacity? You see, the bar examiners are throwing a curveball at you here because, in truth, the capacity to manage one's affairs in a trust, to invest and do all those things that people do in managing a trust, is a much, much higher standard than testamentary capacity. So the basic central issue we begin with is, does Tess have testamentary capacity? And to do that, I'd like to go into our learning environment and take a look at the precise law, and then we'll try to analyze that precise law. What does it take to have testamentary capacity? Okay, so we're in wills here, and let's go to validity. What do we need for a valid will? 3 elements: testamentary intent, capacity, formalities. Intent's not a big issue. She's giving away property. Formalities, we were told, were dealt with, so the only issue we're left with is capacity. And if we look at capacity, well, she's certainly 18 or older, so it's mental capacity is what we want to look at. And here it is. In order to have the mental capacity to make a will, one must know the nature and extent of their bounty, the natural objects of their bounty, and the nature of the disposition. If we apply this law to the facts in our hypothetical, the facts tell us that she described her assets in detail. Thus, she knows the nature and extent of her bounty. As to the natural objects, she was very, very careful. She cut Greg out. She left Susie in. She kept Zoo in. So she seems to know the natural objects of her bounty. The nature of the disposition, again, she was savvy enough to say in trust, and to actually create a trust. We're going to come to that next. Was it a valid trust? But she said in trust, and she described everything carefully. She appears to have the capacity to make a will. In my opinion, Will 3 is valid. Will 3 being the most recent will control. So let's go back to the hypothetical. Assuming Will 3 controls, then here's what we would be able to say. We have valid Will 1, but valid Will 3 in 2014 is subsequent to Will 1 and revokes Will 1 by inconsistency. The inconsistency is Greg is cut out. Greg is included in Will 1. He's not included in the 2014 Will 3. So therefore, Greg is cut out by that inconsistency. And also on the 2013 will, even if You didn't argue breach of trust to invalidate that will or void that will. We have the 2013 will being invalid as being revoked by the inconsistency. Again, instead of outright gifts, we have a trust, and we also have a remainder going to the zoo. The next question is whether or not we have a valid trust. Whenever you have a trust in a hypothetical, I recommend you form it. So what do we need to form a trust? Again, let's go back to the actual law. Let's see what the law is, and let's apply our law to these facts. Okay, so the issue is creation of a trust, and let's look at it. You need 5 elements: intent, purpose, raise, trustee, ascertainable beneficiary. Let's look at the specifics, and we need to discuss them. What is intent? What is trust intent? All right, so the intent to create a trust is that the settlor must intend to divide legal and equitable title. The settlor, the person who creates the trust, that's Tess. She must intend to divide legal and equitable title. Now, what we see here is she gives a life income estate to Susie. So that is creating beneficial title. Beneficial title is the right to benefit, and Susie gets the right to benefit. Legal title is the right to manage, and that is vested in a trustee. Now we have a problem here in that those facts do not specify a trustee. So Tess failed to designate a trustee. What does that do? Let's look at the law on trustee. There's the rule the bar examiners wanted you to have in your book. No trust will fail for lack of a trustee. The court will appoint one. Therefore, the failure of Tess to appoint a trustee would not invalidate this trust. So far, we do have a valid trust. Now, going back to intent just for a minute, I'd like to draw your attention to this issue of precatory words. Precatory words are words of desire. Well, we have what might be construed as precatory words in that Tess said to zoo for the care of the elephants. And I'm going to come back to this one. I just want you to think about it. Now, are those commands that are enforceable by law for the care of the elephants? Or are those merely words of desire? In my opinion, precatory words would be a big issue on this particular question. All right, we need purpose. When you're dealing with purpose, just look on its face. What is it doing? It's creating a life income estate for Susie. She gets income during her life. Remainder, some type of remainder or trust going back to zoo at the end of the day. So this does not violate public policy. It's legal. Therefore, we have no problem there. Raise. The subject matter of the trust must be certain and identifiable. They did that for us very simply. They said Tess's property. No problem here. We have a raise. It's Tess's property. And then finally, ascertainable beneficiaries. Well, the rule says there must be ascertainable beneficiaries at the time the interest matures. Interest matures immediately because Susie gets her benefits right away. She's going to be getting her life income estate right away. So therefore, Susie is an identifiable beneficiary. But we do have a problem here when we look at the gift to zoo. What does zoo have? Does zoo have a private trust? Does zoo have a charitable trust? There's a possibility that zoo has a charitable trust. So what we always recommend you do after you form the trust is you try to type it. So let's look at the various types of trusts. All right, testamentary versus inter vivos. Testamentary trust is a trust, the terms of which are in a will, and takes effect on the death of the testator. In this case, we have a testamentary trust because the terms of the trust are in the will. Therefore, the trust will be effectuated at Tess's death. Tess has died, so now the income trust begins. It's compared to an inter vivos trust where the transfer is during the lifetime, but in our case, we have a testamentary trust. The other problem, though, is do we have a charitable trust? What does zoo have? Now, this is something I'm going to come back to, but one possibility here is they were given a charitable trust, and that should have been discussed. Does zoo have a charitable trust? So it has to have a charitable purpose. Here, the charitable purpose could be to take care of elephants. It could also be to benefit the people that like to go visit elephants or go visit the zoo. Now, our second element is for a charitable trust is it must be in favor of a large number of unidentifiable beneficiaries. And here, we cannot have the elephants as the beneficiaries. You can't have an animal as a beneficiary of a trust because the animal cannot enforce the trust. There is this concept of honorary trusts for animals, but those have to be domestic animals. So we have a problem here. We have to figure out who are the unidentifiable beneficiaries if we want to call this a charitable trust. In our particular case, again, we could say the unidentifiable beneficiaries are the thousands and thousands of people that will go to the zoo and visit the animals, and in particular, visit the elephants. So therefore, we could label this also a charitable trust as one of our legal theories. Now, you'll note, now that we're here on charitable trusts, that Call 2 expressly asked, how can or can zoo modify the trust? Zoo has a petition to the court to modify the trust for the care of the animals. So the proper doctrine to use here, and this is what you want to tell the bar examiners, and this issue had to be in your book, I believe, the Cypre doctrine. Cypre doctrine allows for the modification of a charitable trust. It says when the specific charitable purpose can no longer be achieved, the trust may be reformed when necessary to carry out the intent of the settlor. If we look at this, the intent of the settlor appears to be to care for animals, to have the zoo care for animals. And the last elephant died. So there's a problem here. However, if we look at the whole thing, what happens if this fails? If it fails, then what's left over is going to result back to the settlor's estate to be divided by the rules of intestate succession. And what would that mean here? What that would mean is we've got only know about two relatives, the grandchildren, Greg and Susie, and by this time, Susie would have to be dead. So therefore, that would mean Greg would get the entire remainder. That is specifically contrary to the intent of Tess. So under all of these facts, and you could have argued it either way, you have to argue what the court would do to effectuate the intent of the settlor here if you want to use the Cypre doctrine. And I think as long as you used your facts and made good, clean arguments, you would get full credit. All right, so we've dealt with these trust issues. Let's move on because there's other issues. Let's go back to the hypothetical. Okay, we know that Will 3, 2014 will controls. We know there's a valid trust. And we know that there's a valid will because Tess has testamentary capacity. Our big problem here is what does zoo have? And we have to slow down and be careful because I see a lot of possibilities here. Now, one possibility is, as we've discussed, is it's in trust. And we've already discussed the possibility as if it were a trust. And if it's a trust, it's dicey whether or not zoo is going to prevail. You're going to have Greg on the other side, and Greg is going to say, look, there's no elephants, and she wanted the elephants taken care of, so zoo can't do that. So zoo's got a problem there. However, zoo has other theories. Now, one theory we've been alluding to is zoo has a remainder. I mean, look at what she said. It says, at Susie's death, any remaining assets were to go to zoo. That sounds like a remainder. Sounds like a vested remainder to me. And then for the care of its elephants. And the issue is, what does for the care of its elephants do? I've already discussed the possibility that these could be merely precatory words. If they're merely precatory words, in other words, words of desire, and as I said, this happens a lot in trusts where people, and wills, where people say, I'd like to see this, I'd like to see that, but they're not binding as a matter of law. Now, when the language goes to a charitable cause, the courts are more likely to enforce it as being a command as opposed to precatory language. So remainder is a possibility, an outright remainder is a possibility, but I think the better view, and this is the toughest part of the hypothetical, the property law crossover here. I think the better view is this is a vested remainder. It can be viewed as a vested remainder subject to total divestment. And what that would mean is if zoo doesn't have animals to care for, this clause would completely divest zoo. Again, in that case, what would happen is that zoo gets cut out and Gray gets everything again. So we see the dilemma that the courts would have yet again. And again, this is a very imprecise hypothetical. There's no clear, bright line. I can't give you the clear, bright line. What you have to do is argue the possibilities in the alternative, which is what we're doing here. If I had to come down, is Zoo's petition likely to be granted? There are several theories to recapitulate, and we could even add another one now that we're at that call. One possibility is the court could say to Zoo, look, this is premature because at this point in time, Susie is not dead. And who knows? Maybe Zoo will get an elephant in the meantime. So that's a possibility. Another problem and possibility here is that the court could say, Zoo, you don't have standing. Normally, if there's a charitable provision, and especially, say, for example, a charitable trust, it's the Attorney General that has to enforce the charitable trust. So if we want to argue charitable provision, maybe we're going to need the Attorney General here. This was tested on the last bar as well. And they wanted you to know that it's the Attorney General that enforces charitable trust. Okay, so it could be premature. You can argue that legal theory. You can argue it both ways. You can argue in the alternative. I recommend arguing in the alternative. You can discuss the Cypre doctrine. Some people might even say it's a private trust, so let's talk about the doctrine of changed circumstances. That's the second theory, and for a private trust, we can modify it by the doctrine of changed circumstances. We can call it an outright remainder with precatory language, or we can call it a remainder subject to total divestment. These are the big legal theories. I suspect you had to see at least 2 or 3 of these to get by on this call. Now, finally, let's get what rights, if any, do Greg, Susie, and Zoo have? Well, it's pretty simple. Greg has been cut out. If Zoo's prevails in getting the court to change the terms, then Greg is totally cut out. If Zoo gets cut out, however, is unable to succeed, then Greg will get the remainder, as at this point in time, Susie will be dead. However, Susie does in fact have the life estate, the income life estate to get income during her life, and Zoo, we've discussed, has possibilities. They may get the gift under any one of a number of theories, or they may not.